So what is data preservation? Data preservation is the process of retaining documents and electronically stored information, including document metadata, for legal purposes, and includes a suspension of the normal document destruction policies and procedures. So when does the duty to preserve the data arise? How do you know when you need to preserve the data? The duty to preserve electronically stored information arises when a party reasonably anticipates litigation. Now, various courts have examined what reasonably anticipates means. Obviously, the receipt of a formal complaint, a subpoena, or a regulatory notice will trigger the duty to preserve. But the duty could arise simply on the basis of an oral or written threat of litigation. If a party orally threatens to sue your client, then depending on the circumstances, the company may be required to begin the identification and preservation of relevant data before that lawsuit is even filed. Also, company incidents such as major accidents or employee injuries while on the job may trigger the duty to preserve the relevant ESI, especially if litigation such as personal injury, workers' compensation, or products liability suit is expected. This may be before a suit's even threatened, much less filed. Courts have also considered a company's litigation history in determining when the duty of preservation arises. If similar incidents in the past have resulted in lawsuits or claims being filed against the company, then there may be an ongoing duty of preservation. Many oil and gas companies, for example, are constantly defending against environmental lawsuits. In certain situations, those companies may be under an ongoing and indefinite duty to preserve data for current and future litigation. We have a general idea of what custodians have the relevant data and where the data resides. How do you act? How does a company or your client act on this duty to preserve the data? The industry standard is the issuance of a legal hold plan. A legal hold is a communication issued as a result of current or reasonably anticipated litigation, audit, government investigation, or other such matter that suspends the normal disposition or processing of the records. The legal holds can encompass procedures that affect data that is both accessible and data that is not reasonably accessible. And this specific communication to the business or IT organizations and custodians can also be called a hold, a preservation order, a suspension order, freeze notice, hold order, litigation hold, or hold notice. Most companies have a document retention plan or a document destruction policy in place whereby they back up, archive, and eventually dispose of data after a period of specified time, normally after a few years. The legal hold plan will suspend that destruction policy throughout the pendency of the litigation to ensure that no potentially relevant data is lost or destroyed. Although it's not required by law that litigation hold notices be sent, it behooves you to do so for a number of reasons. First, litigation hold notice can set the agenda for the Rule 26F conference. It gives you the groundwork for discussions involving the issues regarding retaining data from certain sources or data that may not be reasonably accessible. And the notices should be sent to the custodians involved in the lawsuit at hand, as well as to opposing counsel or third parties that are or may become involved in the suit, or who possess potentially relevant information.